Hi, my name is Michael Burgis and I'm an attorney. I wanted to take a few minutes to discuss some recent changes in the law in regards to California workers' compensation medical treatment requesting. Prior to Senate Bill 863 and prior to 2013, it was relatively easy to get medical treatment, and an applicant attorney could go into court and fight for an injured worker's right to requested medical treatment. In fact, the burden was basically to show that the requested treatment was needed to a reasonable medical probability and that would cure or relieve the effects of an industrial injury. And once again, if something was denied, an applicant attorney could go into court and argue in front of a judge that whatever the requested treatment, whether it be therapy, injections, medication, surgery, whatever was needed, and the court could award it. There has been a change in law that went into effect in 2013. That's called Senate Bill 863. And there's been recent case law, Dubon 1 and Dubon 2, that's D-U-B-O-N, that has recently come down. It's an in-bank decision that is binding. And effectively what is in place now is if you have an accepted industrial injury and you're treating in a insurance company's medical provider network and your doctor is requesting some sort of treatment, whether, like I said, it's therapy, injections, medication, surgery, whatever it may be, what they need to do is they need to do what's called an RFA, which stands for a request for authorization. What that RFA does is it's just a request for authorization for the surgery or the treatment or whatever it is. Now that RFA goes to something called the utilization review department of an insurance company. Basically, you have an insurance company that has a group of doctors that review those medical treatment requests to determine if they're going to certify it or decertify it, basically accept or deny it. Now what happens is an insurance company, an insurance doctor sends the RFA into the utilization review department. What the utilization review department is doing in determining whether they're going to certify or decertify is they're looking to see if that request complies with something called medical treatment utilization schedule, or when applicable, what's called ACOM, or American College of Employment Environmental Medicine. So essentially, what they're doing is they're looking for certain factors, okay? And they're looking to make sure those factors are met, and if those factors are met, theoretically the utilization review department is certifying it. Now what's happening is oftentimes you're getting a doctor in the insurance network who is either not properly justifying the medical request or not outlining it correctly. So what happens is this doctor sends in a deficient request to the insurance company's utilization review. Then what happens is that utilization review is denying it because it's not comporting to whatever the requirements are. Now, once upon a time, I used to be able to show that the utilization review denial was legally invalid and go to court and fight for my client's benefits. The laws have changed now. In fact, the only way I can go into court and argue is if the utilization review denial was untimely. Now, generally what happens is when a doctor sends an RFA into the utilization review department, they have 5 days to respond. If they don't respond in 5 days, the utilization review is legally deficient. That does enable me, pursuant to that recent case law, Dubon 2, to go into court and avail myself of the jurisdiction of the court to argue my case. Now, it is not automatically deemed approved if it's late. That just gives the court jurisdiction to hear the issue. I still then have to prove that my client needs the requested medical treatment, that it is reasonably medically necessary to cure and relieve the effects of the industrial injury. But furthermore, with the recent changes in Senate Bill 863, I have to show that the requested medical treatment is compliant with MTUS, once again, Medical Treatment Utilization Schedule, or when applicable, ACOM. And if those are inapplicable, I have to show it's within a general scientific accepted practice. It's a very difficult burden. And if the primary treating physician or the doctor in the insurance company isn't setting the medical record to establish this, it's very tough, if not impossible, to do so. So the point of this, and the reason why I really wanted to have this editorial, was to explain how complicated the laws are and how you really need to elect a very, very good primary treating physician who understands the recent laws, who understands medical treatment utilization schedule and ACOM, and how to properly justify or code the request for authorization so that the treatment gets approved through an insurance company's utilization review. Because if it gets denied by utilization review, my only remedy as an attorney is to go to court if it's untimely. If the utilization review denial is timely, I can't avail myself of the jurisdiction of the court. I can't go in and argue. The only remedy is to appeal that utilization review to something called IMR, Independent Medical Review. This is essentially an independent body of a group of doctors. You don't know their names, you don't know their experience, you don't know their background. Basically, you appeal the utilization review, you put in the medicals that it's based upon, and you hope that IMR comes down and overturns the utilization review denial. However, statistically speaking, it looks like about 86% of all IMR appeals are upholding the utilization review denials. So essentially what's happening is severely injured workers are being deprived of, in my opinion, reasonable medical treatment. And what's happening is these insurance companies are being rewarded by hiring doctors in their network who are not properly requesting the medical treatment or are not justifying the request properly, which then enables utilization review to deny the medical treatment. And our only remedy is to appeal to independent medical review. But the problem is, without the medical record justifying it, independent medical review is going to deny. So the recent changes in Senate Bill 863 have caused a very dire and bleak outcome for injured workers in California. It's very, very important. If you have any disputes in medical treatment, you need to seek an attorney quickly and promptly. There are time limits. If utilization review denies your case and you've appealed to IMR and it's denied, technically you're barred for a year for requesting that same treatment unless there's a change in circumstance. So in reality, rather than fighting it on the back end, you really need to take a proactive approach. You need to find a very good doctor in the medical provider network who knows how to request this properly. You then need to determine if there's any legal deficiencies in the utilization review, mainly if it's untimely, to see if you can argue in court on this issue. To go over some of the key changes in Senate Bill 863, prior to Senate Bill 863 and prior to 2013, the burden was to show that whatever a doctor would request for medical treatment, that treatment was needed to a reasonable medical probability to cure or relieve the effects of an industrial injury. After Senate Bill 863, that burden still technically applies, but medical treatment utilization schedule is presumed correct as to reasonable medical probability. What that means is, in order to show reasonable medical probability, you need to show that certain elements or requirements are met. For an example, in order to have a cervical fusion, medical treatment utilization schedule incorporates something called ACOM. And basically what you need to show is an industrial injury at the location where surgery is requested, that there's objective medical evidence like an MRI verifying that location of the injury, that there's EMGs that are positive and confirm radiculopathy, that there's been exhaustive conservative therapy, that there's been injections that temporarily relieve the pain or symptoms. So you basically need to document medically that all these elements are met before a cervical fusion will be needed to a reasonable medical probability. This is just an example. I'm not a doctor. I'm not going over all the specific elements, but you need to have a doctor who's going to understand what requirements need to be shown in order for the utilization review department to approve that. Because if the utilization review department decertifies it or denies it, your only remedy, unless it's untimely, is to go up to IMR or independent medical review, in which case they're pretty much going to rubber stamp whatever utilization review is doing. At least 86% of the time, that's what they're doing, because they're literally just looking at whether the treatment requests are consistent with MTUS or ACOM if applicable. So Dubon 1, when it came out, it availed the Workers' Comp Appeal Board of jurisdiction when the utilization review was legally deficient, including if it was signed by the wrong doctor, whatever the case may be. That's been overturned by Dubon 2, which is an en banc decision. The only jurisdiction for the court now is based upon an untimely utilization review, which means all other legally deficient arguments, everything is deferred to IMR, independent medical review. And basically, the legislative intent on this was to have doctors really commenting on whether something is reasonably medically necessary. And I agree with it in theory that you want doctors commenting on this, but in reality, if you're having a doctor do an inadequate request without proper justification, there really is no good way to get this overturned by independent medical review. So you really need to get an attorney who can get in on the front end of this case, who understands medical treatment utilization schedule, what elements need to be met to show that a treatment request is needed to a reasonable medical probability and consistent with those guidelines so that you can get it approved through the utilization review, or you can appeal it through independent medical review, and if you have sufficient justification and documentation that the treatment request is consistent with MTUS or ACOM when applicable, hopefully you can get it overturned on appeal through IMR. So once again, my name is Michael Burgis. I represent workers' compensation cases in California on top of employment issues. If you're having any concerns or questions with medical treatment, whether it's being denied or how to get something accepted, very, very complicated, feel free to give us a call. My office is here, standing by and willing to answer every question you have.